Lucy Connolly will walk free from the Peterborough jail this August, having served just 40% of her 31-month sentence for inciting racial hatred. The tweet that led to her imprisonment, posted in the wake of the Southport murders last year in July, was vile, emotional and plainly dangerous. It read, "Mass deportation now, set fire to all the hotels, full of the for all I care. If that makes me racist, so be it." Viewed over 300,000 times in 3 hours, it came in the middle of violent national outburst. It was fueled by false rumours that the killer was an illegal immigrant, many of those rumours fueled by questions asked by sitting MPs, who in turn defended their questions by saying they relied on stories put out by Andrew Tate. Well, that's a really good source. The case raises sharp questions about freedom of expression, judicial consistency, and the politicisation of speech offences. On one side, we have a woman expressing in coarse, reckless language grief and fear. On the other, a clear legal threshold was crossed. Her words arguably incited real-world violence. Migrant hotels were in fact targeted in arson attempts during the riots that followed, though arguably they weren't necessarily caused directly by her. Critics of the sentence, including Nigel Farage, Richard Tice, Kemi Badenoch, even Liz Truss, all the same type, argue Connolly's punishment was excessive and politically motivated. Chris Philp, the Shadow Home Secretary, compared her sentence to more lenient penalties given for actual assaults. Suella Braverman called it evidence of a two-tier justice system. Reform UK has made her a political symbol, with Tice visiting her in prison and denouncing her treatment as abusive. And to add to this, we saw the ex-MP Mike Amesbury, who assaulted one of his own constituents, beat him, left hand thump, not once but 6 times when his back was turned, and he was given a prison sentence which was then commuted. He was granted significant clemency. Why was he granted clemency when Lucy Connolly was not, at a time when the government is complaining that the prisons are overcrowded? Does Mike Amesbury pose less of a danger than Lucy Connolly? Both of them are said to have learnt their lesson, quote. Yet the judiciary stands firm. The Court of Appeal in May rejected her plea for leniency, with Lord Justice Horrod stating the sentence was not manifestly excessive. The court noted that her post risked inciting real violence and was plainly intended to stir up racial hatred. Keir Starmer has backed the verdict, saying he will always defend the judiciary and the rule of law. The dichotomy reveals a fissure in British politics and society. Is online speech, however revolting, grounds for a custodial sentence if it does not directly cause harm? Or does the very scale and context of social media mean that speech itself becomes action? Here, context is crucial. Connolly's post occurred during an eruption of tension in which mobs were looking for scapegoats, and her words may not have lit a match, but they certainly helped fuel the fire. And we must also ask whether there is consistency in how the law is applied. It's true that others, including rioters and physical assailants, have received lighter penalties, and this undermines public confidence in judicial proportionality, but that criticism does not exonerate Connolly. 2 wrongs do not negate the real dangers posed by incitement, particularly in a volatile national moment. What's most troubling is how this case has been instrumentalised. Reform UK, emboldened by a populist surge, has adopted Connolly as a martyr for the cause of free speech. They talk about hurty words. They do not defend the content of her remarks, but they use her case to hammer the system as biased, elitist and anti-British. And it's an emotive narrative, but a dangerous one. By dismissing hate speech prosecutions as woke overreach, they risk excusing real threats to public order. As Connolly leaves prison, likely with a glass of Whispering Angel in hand, the case remains a litmus test. It forces us to confront the difficult question of when offensive speech becomes criminal. It's not enough to say free speech matters. We must ask free from whom and at what cost. In a democracy, the law cannot punish people simply for being bigoted or offensive. But when that expression fans the flames of racial hatred, and when it contributes to an atmosphere of mob violence, it ceases to be merely speech. And the Connolly case should be neither celebrated nor ignored. It should be studied as a warning of what happens when words are weaponized in moments of national trauma and intemperate use of social media.